Hello, good morning, good afternoon, good evening to everyone, wherever you are in the world. I know here on the call we have a Midwesterner, we have Will from California, and Marie, thank you for joining us from Germany. So I'll let our panelists introduce themselves in a minute. This is usually the time I will give you all a quick commercial about who we are. The NAUMD is the Network Association of Uniform Manufacturers and Distributors. Once a year, we put on an in-person event, which I'm excited is coming up in May. It's going to be a great event in Daytona, Florida. 20 different speakers, 70 different exhibitors. We'll give away 30 or 40 different awards honoring the industry. It's really a great high-level way to network with the C-suite and VPs and managers at all the top companies in our industry. We are all about improving our supply chains, which is what this webinar is about, innovating and building awareness. We believe heroes wear uniforms. We believe uniforms empower employees, and we believe that our industry members make good corporate citizens, despite, as we were just discussing before everyone's arrival, America, US potentially being behind Europe in some of this due diligence work on sustainability and being good corporate citizens. But that's a little bit about us. We're involved in the general uniform industry and the image apparel industry, and definitely our strong heritage is in the public safety space, law enforcement, fire, EMS. We produce news. You can opt into our news even if you're not a member. We give out awards. We have networking groups for our members. We produce the convention. We have an online library, which the recording of this will be in the library at theuniformnetwork.com. If you're a member, you can set up a profile. We have hundreds of articles in there, about 80 hours of video at this point, and that's a growing library. Okay, that's enough of the plug about the NAUMD. I'm very pleased to have these two professionals with us today. Marie from the Sustainability Development Manager at Hohenstein, and Will from an attorney at Norton Rose Fulbright, who are going to educate us on the topic of navigating due diligence. And I will, because since I am not a subject matter expert, not say any more on these topics, and let the two of you introduce yourselves as you wish and tell us. So thank you.
Yes, thank you, Rick, for introducing us. Thank you for having us in this webinar on this very important topic of due diligence. We discussed a lot before, and there are a lot of different regulations, different topics coming up in the US, and I'm happy to bring the German European perspective in this call today. My name is Marie Oldop, and I'm working for Hohenstein, which is the testing certification company. I'm located in Hamburg, Germany, so quite far away. It's evening for me, so I'm happy to be in this call today. Let me check to next slide. Yes, just some figures about Hohenstein itself. We are a family business since 75 years, experienced in testing, certification, and research. We have around 1,150 employees around the world, with the main headquarters in close to Stuttgart in the south of Germany, at a beautiful castle. And we are a founding member of Oekotex, which is right now in Europe the minimum standard for chemical and physical testing. So Hohenstein is one of the most important laboratories for Oekotex. Apart from that, apart from the testing certification, we developed also sustainable consultancy services. So this is one of my main work, working on due diligence topics as well as sustainability strategies. So I will give you now an introduction of what due diligence actually means and where is it coming from and what kind of components are included in the due diligence process. And then I will hand over to Will, who is giving an overview about mainly all the regulations, well, not all, but the main regulations that are important for you to know, that at least you have to know what kind of buzzwords you need to search on to go a little bit deeper. And then I can give you a small step-by-step guideline on what to start and where to start as a company with working with due diligence. Due diligence is nothing new. It was defined already by the OECD 7 years ago, and it's defining the process enterprises should carry out on identifying, preventing, mitigating the actual risks and possible impacts that you have in your own operations, but also in your supply chain. So in this definition, there's already a lot of topics that sounds quite complex, and it sounds quite complicated to work on, because it's not just identifying the risk, but also working with this risk and preventing and mitigating it. And it's not just only including your own operations, but also your full supply chain and business relationships. Due diligence was, of course, developed or defined in the OECD guidelines, but also the UN guiding principles on business human rights also have the components of due diligence included. So these are here some frameworks that are useful to read and includes the main components of due diligence. And we already have here a guideline for garment and footwear sector. So we have already a guideline which is specifically focused on our sector. All these frameworks, all the due diligence definitions by the UN, by the OECD, always includes these 6 components, which starts with the responsible business conduct. So defining what you actually want to work on, what does due diligence mean for you. Then you work on a risk analysis. Based on the risk analysis, it's preventing and corrective actions, what kind of ever risk you define and you find in your supply chain and your own operations. The question is always to assess the effectiveness. So you always have to have a continuous process to assess that it's continuously improving. You have to have a complaint mechanism, and you need to report and document it externally so that it can be easily understood and seen. I will go a little bit deeper later on what does it actually mean and how you actually work on it. What is interesting is that due diligence is very different to what regulations we have before. Before it was more on human rights, or when we think about BSCI, we have human rights, labor, workers, rights in your supply chain. But this includes human rights and environmental aspects like prohibiting harmful substances, working on environmental aspects in your global supply chain. So it includes your own enterprise, your direct supply chain, and your indirect supply chain. So that means if you know like a specific risk in your indirect supply chain, you need to take action as well. But I think we'll explain that a little bit further. What it actually means is embedding the responsible business practice in your policies and in your management system. It's not enough that you just publish a policy and then it's done. You need to include it in your management system. You need to identify and assess possible risk in your own operation and your supply chain. And this is quite a big topic because risk analysis includes always the gross risk, like in your sector and the countries that you are working on, and the net risk, like the concrete risks that are possibly occurring in your supply chain. So based on factory visits, for example, or on audit reports. And then you need to work with these risks, like preventing and mitigating these risks in your supply chain. So the goal is in your own operation that there is no risk possible or found. You need to track the implementation and the results. So this is this continuous improvement that you always need to work on. And of course, you can work on cooperations to improve or mitigate the risk that you find. Communicating, as I said before, is a big topic. Based on the regulation, you always need to document and communicate what you have done. So you need to publicly communicate about the risk that you found and how you actually work with. When we think now, I think it sounds quite logical that we need to work on it. So I think many companies should actually work already on it. but we still know that there are a lot of supply chain risks actually happening. And we still know that even though we have a lot of regulations already in place, we still know that there's a lot of pollution happening, a lot of human rights violation in our supply chain. And I just here have a few. When we think about, for example, forced labor, we still have it in China. We have prison workers who have forced labors of minorities in China, for example, or in Uzbekistan, where we think actually we kind of mitigated this risk or try to work on it. We still have it in our supply chain. We have garment workers who are going on massive strikes in India. We have still fashion brands and textile that are polluting the water in the production countries, because it's always the main environmental pollution is always in the production countries. We know from reports that only 15% of the textile companies have full visibility of the supply chain. So that means that some of you maybe also know your direct supply chain partners, your cut-made trim partners, but as soon as you go deeper in the supply chain, no one actually knows. And at the same time, we know that 70% of the greenhouse gas emissions, for example, are upstream in the production of the new clothes. So actually, in all this, where we don't know where it's produced, there's also the main risk of environmental pollution. Because also more than 3,500 chemicals are used in the textile production, which is a lot. And we have around 10% of it are very toxic to human bodies and to the environment. So the idea is to actually prevent and get these chemicals out, but for this we need to know where they're actually found and used. And we have more than 300 million workers in the global textile and clothing, leather and footwear industry. So we have a lot of potential risk. And when we think about this 15%, maybe you even think of, yeah, maybe it's good that I don't know what is happening in my supply chain. But this is also a big risk because it's bad reputation. You don't want to be someone where researchers find out that there's something happening in your direct supply chain. So when we think about this regulation, it can be very beneficial for us and very good for us also for a competitive advantage to work through due diligence in your supply chain and in to mitigate these actual risks and to be sure that there's nothing like environmental pollution or human rights violation in your direct supply chain. And with that, as an intro about due diligence, I will hand over to Will, who will give you the legal background about this and give you an introduction of what you need to know about due diligence in the legal framework.
All right, thanks, Marie. Hi, everyone. Thanks, Marie. Thank you, Rick, for having me. Again, I'm Will Troutman. I'm a partner in the Los Angeles office of Norton Rose Fulbright. I am a regulatory compliance lawyer focusing on issues for the retail and manufacturing sectors, primarily in consumer markets, and that includes both chemicals compliance, product safety, but as more and more growing ESG, supply chains, modern slavery, and related issues. So I'm going to pick up where Marie left off here, talking about the legal background that we're seeing in this space. In one of the earlier slides, Marie put up a number of frameworks that tie into due diligence, and what we're starting to see, especially in the European Union and the UK, and now more and more in the United States, is a convergence where laws are actually adopting these frameworks into requirements, and then with them are coming, penalties, punishments, and risk associated with that. So looking here at this issue and the evolution of due diligence, as Marie noted, it is common for brands to only know their tier 1 suppliers, and for manufacturers and suppliers to have limited knowledge of their upstream partners, often relying on annual audits or at onboarding to look at manufacturing facilities, subcontractors and raw material suppliers, if at all. And to hope that contractual obligations are actually flowing through the supply chain, and that if and when things do go wrong, that all of the various supply chain partners are going to be in a position to make good on their obligations. unfortunately, it's not often the case that this plays out this way. We're seeing a shift now in how this is all playing out in the legal landscape. Back again, mentioning 10, 15 years ago, part of the reason for supply chains to not have a lot of knowledge of, upstream entities, depending upon where you are in the supply chain, was frankly, it was a competitive advantage. And so supply chain partners were viewed as confidential business information, and nobody wanted a downstream partner to go around them to find a better deal or a more direct supply. When I started doing this work back in 2010, which is when the California Transparency in Supply Chains Act came into effect, that's a law that requires textile companies to disclose efforts they're making to combat modern slavery in their supply chains. That law didn't require anything in particular other than simply saying, what are you doing? And I had many conversations with clients where they said, I don't know, we don't know. And not only don't we know, we can't find out, because if I go to my tier 1 and say, I need this information about, tier 2, tier 3, all the way up to raw materials, they would say, no way, we're just not going to give you that information. Well, I'm in part driven by EU regulations, now joined by the United States, and also to a certain degree by consumers and companies because of the rise in ESG issues and obligations. It's not really the case anymore that folks can say, I don't know anything about my supply chain. And because of these due diligence laws that are coming into place, there is now an expectation that you will know that. And that is both a good and a bad thing. It's a good thing that the laws are in place because it does give supply chain entities leverage to say, I need to know this information because I have a legal obligation. It's a bad thing because the person who's getting the information is assuming legal risk for that information. And even if you're getting some, it doesn't mean you're getting all, and it doesn't mean that it is truthful and accurate on a day-to-day basis. Just to give a very minor anecdotal example, as I mentioned previously, the California Transparency in Supply Chains Act required disclosures about efforts. It did not require disclosures about specific things that happen. And we saw a number of lawsuits be filed back then in the regarding products in the cocoa and seafood industries because of news programs that were doing exposés on child labor in these industries, and NGOs brought lawsuits saying your disclosure says you don't have modern slavery in your supply chain. 60 Minutes says you do. We think that you're lying to us. Now, ultimately, the courts in that circumstance said this is not what the law requires, but that started setting the stage, and it shows where we are headed with regard to this in terms of legal risk. So I'm going to talk a bit here about some sources of legal risk, giving some examples. Now, there are a growing set of laws and regulations almost daily. And we don't have enough time in a week, let alone in an hour, to talk about every one of them, but I'm going to give some high-profile examples and ones that we view as potentially creating the most risk. And it's important to view these laws through a variety of lenses because there is no one common approach. And so what I've put on the slide here are the typical sources of these due diligence obligations. Some of them are direct due diligence obligations, as in the law says, thou shalt engage in due diligence. Others do not have direct, they're indirect due diligence obligations, where in order to comply or at least have a good sense of your risk, you likely need to engage in due diligence, even if not expressly required. And so we have modern slavery disclosure laws. We have these express due diligence laws that cover both sustainability or climate-related impacts as well as human rights. We have supply chain traceability laws requiring that an entity, the brand or the person selling the product at the end of the chain know everything about their supply chain back to the raw materials. And then we also have a couple of what I call soft law obligations, which are substantiation laws. These are claims-based laws. So if you're claiming your product is carbon reduced, if you're claiming your product is ethically sourced or sustainably sourced, these are laws that are requiring certain information to substantiate those claims. And then finally, just a quick mention about how all of these laws relate together. And while you might not be specifically covered by one, because of scope restrictions, by virtue of being in a supply chain, it is likely that someone else is, and they may be coming to you for information to help them fulfill their obligation. So I'm going to start out here just by terrifying everyone and showing you the enormous number of due diligence related laws in the supply chain context that are either in place or soon will be in place. I'm focusing again on the EU, the UK, and the United States. As you can see from this slide, there is a growing body of legislation around the world that's requiring companies to undertake these types of due diligence obligations across their organizations, so internally, as well as across the supply chain, so externally. To give an example that represents common themes in these types of laws, and Marie, jump in, by the way, and correct me if I'm getting anything wrong here, given that you're in Germany, but I'm going to talk a little bit about the German Supply Chains Act. I'm not going to try to say the German name for that law, which entered into force in January 2023. This law requires domestic and foreign companies with at least 1,000 employees in Germany to address human rights related and environmental due diligence obligations in their supply chains. In-scope companies have to establish an effective risk management system to comply with the due diligence obligations. That includes assessing and addressing human rights risks in the supply chain, such as child or forced labor. They are required to appoint a human rights officer responsible for managing or for monitoring risk management. They need to issue policy statement from the company's senior management describing their approaches to compliance. They need to take preventative measures in their own operations and towards direct supplies with respect to human rights and environmental expectations. So this is onerous stuff and lots of statements that need to be made. And again, it is impossible to have absolute knowledge in real time. So incredible amounts of risk here in terms of what's being said, when what's being required. The German Supply Chains Act is in effect here at the same time that the EU itself is developing its own directive addressing corporate sustainability due diligence requirements, on a union-wide basis. So speaking about that, we have in place the EU Corporate Sustainability Reporting Directive, or CSRD, which represents an indirect form of due diligence. The CSRD came into force in January 2023, and it requires companies to report and disclose information on their environmental and sustainability impacts on society and how those sustainability factors impact their business. This is referred to as quote, double materiality, as it views, again, both internal and external material sustainability factors. I was having an interesting conversation with a client the other day where we were talking about these due diligence obligations, and it was in the context of climate impacts and climate risk to the company. And the whole conversation was about how, from their point of view, the client was asking lots and lots of questions about how their business was impacting the environment. So climate emissions, chemicals use, things of that nature. 45 minutes of the conversation was that. And I said, okay, so now we need to talk about the risk of climate change to your business. And they're like, wait, what do you mean? I'm like, well, what I mean is things like if your raw materials are coming from, an island in the Pacific that climate scientists are saying will be underwater in 5 years, you now have climate risk to your business and you need to be aware of it and to disclose it under some of these laws. And so I think this is another wrinkle that is relatively new in the context we're speaking about here, because it is not just about how your businesses impact the environment, but how everyone else's businesses are impacting the environment, and that's impacting you. And I think that is a next level consideration that is interesting and challenging to approach, and something that's important to start thinking about, particularly if you have investors, if you're a publicly traded company and you're disclosing risk information to them about the long-term viability of their investment in you. Sorry, got a little off track there on that story, but with regard to the actual requirements here, CSRD applies to large EU companies as well as small and medium companies if they meet certain thresholds. It also applies to large non-European Union-based companies that meet certain revenue thresholds and have some presence in the EU. So if there is enough revenue being generated in the EU, and for example, you own a distribution center in an EU member state, you may be caught by CSRD, even if you don't view yourself as actually being in the European Union. General standards for approaching these requirements were finalized in June of 2023. Sector-specific standards are expected, were expected in 2024, but now have been delayed to 2026. So there's going to be some additional guidance that will be sector-specific to folks on the call here. The general standards cover environmental and social issues from climate to water impacts to a company's own workers in the supply chain. Generally speaking, these laws seek to align with reporting standards for non-governmental frameworks, such as ISSB and GRI. So to the extent your companies have already been engaging in voluntary efforts under some of these frameworks, hopefully there won't be too much new work, but it is really important to do a gap analysis or a mapping to make sure that the legal requirements and how you have been interpreting these frameworks are consistent. One of the common things we see is that when due diligence information and sustainability and modern slavery information are being shared by companies on a voluntary basis, where they have information gaps, they either say, we're doing our best to adhere to the standard, but it's not exact, or they say, oh, and by the way, in this really big area, we just don't know, right? And as long as they're saying we don't know, they're generally okay. Well, it may not be okay to have that gap or to not try to do more to close that gap under some of these new legal obligations. So just something to keep in mind as you're thinking about your approaches. Following on from CSRD, we have the most comprehensive approach to due diligence that's been proposed to date, which is the EU Corporate Sustainability Due Diligence Directive, or CSDDD. As some of you may be aware, this requirement or this directive was up for approval by the EU membership just this week. And ultimately, it is currently on hold as it didn't get enough votes. And I think, Marie, Germany may have been the big player here in holding this up. But there was a lot of talk about CSDDD for several years, and there was an expectation it would be put into place. That expectation is now on hold, but I think at the moment there's still we still believe that there will be some form of this in the near future. I don't know if it will be by the end of this year or soon. There will need to be some changes to this to get it into play. But just at a high level, there's still some important themes here, which I think we're going to see. And so I want to talk about them quickly. If and presumably when approved, the CSDDD will not only require companies to identify adverse environmental and social impacts, but it will go a step further and actually require preventative action plans to avoid new impacts, as well as corrective action plans to mitigate the existing impacts you've identified. So on the one hand, you have to say, what are our risks? And then on the other hand, you have to say, and here's how we plan to mitigate them or fix them. And that could range from engaging with the supply chain to correct identified issues. It also could mean all the way to like terminating a supply chain partner if they just can't seem to get it right. And what's so important about CSDDD and why talking about legal requirements versus frameworks is important is that the proposed penalties for non-compliance under CSDDD would be a percentage of revenue. So the non-compliance risks here are potentially huge. And in general, we see a trend on the enforcement side, we see a trend in ESG-related laws for the early days to be big notable examples that get headlines because one of the purposes of penalties is deterrence. And so if you go hit a big known name and you make them pay a whole lot of money, it then tells everybody else, ooh, we better take this seriously and invest in compliance, in manners that are appropriate. So I think it's important to keep an eye on this. And as an off-route, we've been talking about the interplay between the EU and the US. The US at the federal level does not have anything comparable to CSDDD in terms of proposed measures. But within the fashion or retail sector and in the textile industry in the United States, there are several proposed so-called fashion acts, one in New York, one in Washington. We're expecting one in California this year, and potentially even at the federal level. I wouldn't expect it to get passed, but it might be proposed. And the basics of these fashion acts are essentially what CSDDD will require, which is annual reporting on climate and modern slavery risk, as well as mitigation measures, and then identifying metrics to determine whether those mitigation and corrective action policies are actually, effective. And again, the enforcement in the US in particular may not come necessarily from government, but we have a very, very active NGO community that really likes to bring cases against companies for saying things that are ultimately found to be untrue. Next up, we have what I call, in that list of sources, this is a supply chain traceability law, but it is in essence due diligence related, because to avoid getting in trouble on the back end, due diligence on the front end can avoid some problems. So we have the Uyghur Forced Labor Prevention Act, or UFLPA, depending upon how you like to pronounce your acronyms. Some people like to say UFLPA. The customs people that I work with say UFLPA, so since they're the ones in the trenches, I'm going to stick with that. So this is an interesting law because it looks a lot different than the other measures we were just speaking about, both the German Supply Chains Act as well as the CSDDD and CSRD. In sum, UFLPA establishes a rebuttable presumption that goods, materials, or other items with a nexus to the Xinjiang region in China were produced with forced labor. So that could mean the goods originate in Xinjiang, or that the goods were made in connection with a known Xinjiang-linked corporate entity. U.S. Customs and Border Protection enforces UFLPA. If a shipment of imports is stopped by CBP, the importer must produce records showing no nexus to Xinjiang going all the way back to the raw materials. So this is where I'm talking about this being a unique approach to due diligence, because it does not require anything upfront. But if you don't put in the upfront work and you have a shipment stopped, it's going to be difficult to backfill the records needed to actually get products out of hock at the border, at the port of entry. Certifications, at least as of right now, certifications are not enough. CBP expects to see certificates of origin, purchase orders, invoices, bills of lading, and production and inventory documents showing that the materials from the finished good all the way back to the raw materials, as in the cotton, do not have a nexus with Xinjiang. If the goods do originate in Xinjiang but are not the result of forced labor, in addition to the types of records I just listed off, CBP also expects to see proof that workers were not forced or coerced, including things like wage and payment records and details of the employment recruitment process to show they took the jobs voluntarily, they knew where they were going to be when they took the job. They didn't have their passport taken away, things of that nature. So pretty onerous requirements here. And we've seen CBP be quite active. We've also seen Congress thinking they're not active enough and proposing new measures to add more funding and more activity with enforcement here. And so I think this is going to be one of those areas where we're continuing to see issues. And one other just side note here that I find interesting. When this law went into effect, there was an expectation that shipments from China were going to be the things that were stopped. But we actually see that in the statistics, after China, Vietnam, lots and lots of products from Vietnam are being stopped and checked. So CBP is not just viewing this as a China issue, they're viewing this as an overall risk issue, and they're looking to where goods may be moved from China to other countries for purposes of import. Down the home stretch here, and I'm mindful of hearing my own voice, let alone you having to hear my voice so much, but I want to talk a little bit about environmental benefit claims, which also are an indirect form of due diligence. In the United States and the EU, there is a growing, as I'm sure many of you are aware, growing trend for products to be advertised, both on the consumer-facing front, but also within business-to-business transactions, as having sustainable, green, or ethical sourcing attributes. So it's common to see hang tags that say, made with recycled content. It is common to see hang tags that say ethically sourced, sustainably produced, things of this nature. We have two primary legal drivers of risk in connection with those, and they both have a due diligence piece in them. First up, we have the Federal Trade Commission Act in the United States. Overall, the Federal Trade Commission Act prohibits deceptive acts and practices, which includes false advertising. The FTC, the Federal Trade Commission, which is who enforces the FTC Act, has issued what are called the green guides to provide examples of what types of green claims the FTC views to be misleading or deceptive. In the context of green claims, you need to have substantiation, which at root is a reasonable basis. But in the green space, because so often science is involved, this has been expanded to mean competent and reliable scientific evidence. So if you're calling a product recycled content, it is a common expectation that you will have global recycled standard, source scope certificates and transaction certificates demonstrating not only that the fabric itself was recycled, but also that the fabric you are using in your product is in fact that same fabric. So chain of custody in essence through the supply chain. Right now, the FTC is reviewing the green guides, which were last issued in 2012, to update them for all of the new developments in terms of green advertising. And we expect sustainability was not addressed back in 2012, and we expect that there will be some comment on sustainability now, given how often it is used. One other just quick point on the FTC Act. Individual states have adopted or incorporated the FTC Act by reference into their laws, giving state rights of action. So you may, if you're in the United States, you may have heard of the California Unfair Competition Law and False Advertising Act. That is a law whereby California plaintiffs can bring cases, and they use the green guides as the basis for the claim. So there's both federal and state risk there, and there's different levels of activity depending upon the states. Mirroring this in the EU, we have the relatively new Green Directive. What's interesting about the Green Directive relative to the Green Guides is the Green Guides just give examples. They're not legal force. They're just examples. The EU Green Directive actually establishes significant restrictions on environmental benefit claims, saying what you can and cannot say. It bans environmental claims on products without proof. It bans claims based on offsetting emissions. So you can't say this is a carbon neutral product if the product itself is generating lots of emissions, but you're buying offsets by avoiding deforestation in Indonesia or something to that effect, which is a common occurrence. So that's a big sea change in terms of advertising. It also eliminates certifications that are in essence self-created, and so there's lots of certifications out there that are either NGO-based or industry-based. The EU will now need to approve certification schemes in order for companies to say that the product is substantiated or that it's certified. And then finally, what's really important here is that the substantiation, the basis for the claims, has to be accessible to the public. Commonly, right now in false advertising law, typically the only time substantiation comes out is if you actually get to court. There's no obligation to actually publish those requirements, and under the Green Directive, you'll have to do that. Side note on that, California recently passed Assembly Bill 1305, which also requires the publication of substantiation, but only in the context of carbon neutral and net zero claims. So we're, again, new trend, and expect that if you are making the claim, you're going to have to start publishing that substantiation. If you are making products for a company making the claim, expect that they're going to start asking you to provide the data they need to publish the substantiation. And with that, I will take a breath and turn it back over to Marie to bring us home.
Yes, that was a lot of information in a very short time. I think I will take over the screen for the last slides. Yeah, thank you, Will. The question is, what does that mean for us as a company, as a distributor? What can we do about it when we know the due diligence acts are coming, when we know all the different regulations are upcoming in the EU, depending on where you're selling to? I think it's important that you break it down in small steps, because when you read a regulation like this, it's always like too complex, too high the mountain to climb. So let's try to break it down and to see what kind of small steps you can take to actually work on it. And I think what Will also said, we said responsible businesses should look beyond their own operations. We had this double analysis of impacts on the environment and impacts from the environment. So I think this is a very new approach, and I think it's good when you take a step back and start looking at this own operations and what kind of impacts there could be. And you need to look on your global supply chain. So you need to understand your products. This is quite easy to say, but understanding all the components in your products, and need to understand your supply chain to understand the possible human rights violation and the environmental violations, to protect them and to work and improve them. So steps towards due diligence is, first of all, of course, defining what kind of way of what kind of path you want to work on. Maybe it's even easier to start small and to start on specific topics that you want to focus in your supply chain. And then you need to understand your supply chain. How do you do that? You check with questionnaires who is in your supply chain, what are the different production steps that they are having, what kind of products they are producing. And if you want to improve your supply chain, you can use tools for sourcing. There are from certified for certifiers, you can use tools like from the Oekotex buying guide, or for GOTS, you can find already certified suppliers that are listed online that you can look deeper into. And then you need to identify the risk. And as I said before, you can use tools for that. You need to analyze your gross risk and your net risk. So it's always better, even though Will said the certification is not everything, depending on the Due Diligence Act, sometimes it's already like mitigating your risk, because you have a third-party proof of ensuring that there is no human rights violation in that moment of certification, of course, and no environmental pollution, because there is a big certification body afterwards or behind it. Then you prioritize your risks. Of course, you cannot work with all the risk at the same time. So depending on your volume of articles or products, depending on the volume that you're buying at the specific suppliers, you prioritize in which country and which suppliers you want to focus first, and then you work on mitigating, on working with these risks. Implementing a grievance mechanism is a big topic. It's important that you start with your own operations first to establish a really functioning grievance mechanism. And then if you work with certified suppliers, mostly grievance mechanisms are in place already through the certification, or you can even work with the Bangladesh Accord, or in Pakistan that's growing as well, or with NGOs to work with a third-party grievance mechanism so that's reliable and that it's effective. You can use all this, what you have done, to communicate it and show it to your customers, to your clients. And as Will said, maybe not everyone is directly affected by these due diligence acts, but maybe you are affected by your other suppliers or your other clients that you're selling to. So maybe other ones are asking for it, and then you can use it, and then you have it already. When you start working on it, it's important that you monitor and document it so that you have this continuous process and you have this continuous improvement. So having this risk analysis once a year, it's important you document it, and then next year you can just update it so you don't have to start from the beginning. We have you can use an assessment that helps you to analyze your status quo, because it's always easier to check yourself than starting from scratch and starting very alone. So the responsible business is a self-assessment that you can use for the self-assessment for status quo checking, and to see what kind of requirements you already fulfilled. And with that, you can demonstrate your responsible human rights and environmental due diligence. And it includes your own operations and the supply chain. You can also use experts to help you on specific topics to work on it and to guide you through it. And of course, with the responsible business, it's a certification, so you can use it for communication and for showing that you have worked on it. But in my consultancy, I work a lot with the self-assessment. You don't need to have the certification at the end. You can use it as a self-assessment, so you actually know where you are in all this process, and to know where you need to go next and what are the next steps. So these are broke down steps for you to actually work on and to start working on it, because I think it's very important that you do the first step and that it doesn't sound too complex to actually start. I included also my contact And now I will hand over to Rick in case there are questions.
Wow, that's a lot of information. And although you say it, Will, thankfully in plain English, it's it's overwhelming. If people have questions, feel free to either use the chat tool or the Q&A tool in Zoom. They're both down in that control panel area. I made some notes as we were going. Some of them you answered then as we went, but boy, it sure feels to me like it's just like the whole thing is only as good as what the last guy in the chain says, right? And so if the last guy is a bad actor or somebody that has not been honest in some way, does the whole house of cards fall apart? Or how do I protect my company then from that one final, the guy that actually made just the label and we attached it to the garment in yet a third country from where we got the raw goods versus production. I mean, how do you protect yourself from that? Part B of that question is, Marie and Will, do your clients, do they have lawyers in every country? I mean, how does that work?
I'll take Marie, if it's okay, I'll take a first shot at that. And I heard so there's an A and a B. Let me try to get to A first. So the question of how do you protect against, you're only as good as, the honesty of your supply chain partners. And, the short answer, unfortunately, is there is no foolproof solution here. So when I'm talking to clients about these issues, it's really a matter of risk appetite. And so what I think is very important is that as a first step in even thinking about what to do, if you're not doing things already, it's important to get the various stakeholders of the company together to decide as one on what the risk appetite is. And if the risk appetite is, we want no claims, no issues, unless, it's a completely out of the blue circumstance, then the measures of due diligence and the amount of work that you need to do and the costs and expense on the upfront side are going to be higher. And that may mean engaging in a significant supply chain due diligence process and not just taking information from those folks, but going and visiting sites, meeting everybody face to face, potentially visiting on multiple occasions a year. A common process is, a one-time a year audit or something of that nature. We also hear lots about announced versus unannounced audits, and even unannounced audits are still announced for the most part. Unannounced audits usually mean, hey, we're going to be there between X and Y. So, you may want to be thinking about upping that game to be truly, unannounced, like showing up at the last minute and negotiating supply agreements that give you access rights, without announcement. So this is a multifaceted circumstance where not only do you need to decide the risk appetite of the company, but you also need to then look at what the structures are that are in place and figure out what needs to be changed to get you where you want to be. So if you have a manufacturing and supply agreement with upstream entities and it does not give you access rights and audit rights, you probably need to renegotiate those contracts. And if those supply chain members aren't willing to do that, you may want to start looking for new partners who are willing to do that. So I'm wary of using analogies, but it's kind of like buying chicken at the supermarket. You can buy the chicken at the supermarket that's the cheapest, or you can buy the chicken at the supermarket that's in the little section that says organic, or you can go to the chicken farm, right? So, but there's cost and time involved in all of those things. So
I literally thought of that during your talk at some point. I'm like, when I go to the poultry section and it says organic, I'm probably going to buy it, but I don't even know what that means anymore because the definitions are all over the place.
That's right.
Right.
That's right. That's
so,
right.
So Marie,
Yeah.
if a company's going to start, small, right? And someone's asking a question that kind of goes into this, Marie, of like, well, if I look up the laws of where I operate, my aegis, right? Like this is where I operate, and I find that I'm in compliant with the laws. Does it matter if someone, on the other side of the globe isn't necessarily compliant with their laws? I mean, how do you even reconcile that? Because I can't be from a legal perspective, it's not my problem, quote unquote, other than what I'm saying publicly. And part B of that, Marie, is you said at some point, how did you phrase it? That you should publicly communicate the risk to your stakeholders,
Yeah.
whatever those stakeholders are, right? Customers, team members, investors, right? Well, US companies are terrified of that, Marie. We don't want to say things publicly. We don't want to report that there might be a problem. We might say there is a problem, right? We might be incumbent to do that. All right, I'm throwing too much at you all at once. Answer whatever part
I
of
wanted
that.
to answer you the question before. No.
But there's a
No.
specific question someone's asking about.
Yeah. No,
If
so
I'm
many
covering
questions.
all
Yes,
my
but
laws, is that okay, right? Am I then covered?
well, yeah, with this, I think we'll have a better answer. But I think what is the big challenge is always when do companies feel safe, or when do they think they feel safe? And I think many of the companies now starting to have lawyers in their own company to actually, when you said about is that really organic, like these green claims is a big issue right now. Everyone is pulling back their green claims because no one knows. So this is a big thing that everyone is saying, yeah, just say this is a sustainable product, but then you better don't say it. So now everything that goes externally is always going through like a lawyer perspective to be sure that there's nothing that can go back to you. So this is very important. And I think what is also interesting is that there's never the safe way, as you said before. There's no warranty ever that there is no violation in your supply chain. So
Right.
I think what is important to say is that at least in the German Due Diligence Act, there is no warranty at all. You just need to show that you start and work on it and that you take measures, because you can never ensure that you took all the measures to prevent this risk. There's always a potential risk. So you need to show, and this is the quite complicated, and this is what you need to balance when you also say you need to explain it externally, which actual risks are you talking about and which risks are you communicating externally. Of course, you can say overtime, because everyone in Texas supply chain has overtime issues. So you can work on this. At least I would say, well, this is a
So we
direction.
wish everyone were Okie-Tex, certified, right? But you're
That
saying,
would be
and we all
easier.
know that a lot of it is like you said, it's self-assessing. So Will, is it enough then that we're just
Yeah.
asking the questions and getting answers? Or are we responsible for our supply chain partners?
Yeah. So, yeah, there's a bunch of things you said. I have comments on. I'm going to try to serially move through some of them, and I also see in the chat the question of, is there a highest common factor? So I'll address that as well. But I think what's important and what's different here is that due diligence and sustainability and modern slavery have really been thought of in like kind of a side bucket of nice to have. But it's important to start moving it into the same bucket as things like product liability, where on product quality and product compliance issues, product safety, chemical issues, everybody has some form of a compliance approach, whether it's, you test one sample, you're testing routinely through production, et cetera. But when there's a product recall, nobody ever is like, well, we knew this was going to happen. It's just something that pops up and it's unexpected and you deal with it. And so a supply chain partner lying to you is not something you're going to be expecting. And it's just going to pop up. And going forward, you're going to have to deal with it in the same way that you deal with a product liability claim or a product recall as those things pop up, or a rejection of a product, depending upon who you're supplying to. They're now, in my view, in the same type of risk corridor for a company, where it's known the company needs to invest the amount it's willing to invest to get each additional increment of compliance assurance, but you're still never going to know. And there's always going to be a drag on the company over time of risk of non-compliance. The key is, and this is where I tied into risk appetite, is when something goes wrong, does your company want to be in the position where it's saying, we did the bare minimum and now you're adding a PR hit and potentially loss of business? by virtue of looking sloppy, or are you going to say we did everything we could and this was just an unfortunate outlier, and frankly we've had very few outliers, we're a good company? That's really the spectrum we're talking about here of risk. On the highest common factor issue, somebody asked in the chat, is there one jurisdiction you can follow? To a certain degree, yes, but in most degrees, no. And the problem and the reason for that is that most of these sustainability and supply chain due diligence laws require reporting. They don't just require, like, chemical composition. You can say, California has the lowest ppm level. Do that, and we're probably good everywhere else. With these laws, there are actually affirmative obligations to submit information and data to regulatory bodies in the various countries. So to use a concrete example, we had the California Transparency of Supply Chains Act in 2010 that required a public disclosure on a company's website of its efforts to combat modern slavery in the supply chain. Then we had the UK Modern Slavery Act. Then we had the Australia Modern Slavery Act. Now we have a host of in-EU member state disclosure acts and a Norwegian act as well. And they all are slightly different. And you can't issue one statement that covers all of them. You can issue one statement that covers most of them and then have addenda, but there isn't one true answer here. And I think that's what's particularly vexing about these, is that even if the core of the information is the same, it's still going to require submission of information in different ways to different bodies. And so that's important to be careful about. And before you jump back in, Rick, there was one other question about, you made a comment about the local laws in the places where your supply chain partners are operating, and do you need to know those, and what do you do about that? The answer there used to be, probably not.
Yeah.
So every manufacturing and supply agreement says you shall comply with, forced labor, human rights laws, in the jurisdiction in which you're doing your business. Yeah. And that's always been there. And I think most companies just sort of go like, well, we put it in the contract, so if something goes wrong, we'll deal with it. But we've now seen a new trend here where we have the EU deforestation regulation, not to throw another law in there to terrify everyone, but that regulation requires actually geomapping the source of raw materials in certain areas like cattle, cocoa, palm, pulp, things of that nature. So like the base raw material, I think back to Civilization video game when I was a kid, like the raw materials to build a society. But it first requires geomapping. And then second, it requires that the entity importing the products in the EU have some assurances that local law as to environment and labor is being followed by the supply chain. And so we've been working with some clients on this issue, and a common question is like, well, can we just get a certification? And the answer is probably not. If you are going to go that route, at least make sure the certification has been reviewed by a local lawyer to add the relevant provisions into that audit that cover that jurisdiction. So yeah, your face is the exact face that every client has made.
Need lawyers in every country, right?
Yes, to a certain degree, but I also expect that consultants and supply chain support folks like Hohenstein are going to start thinking about approaches. If they're not already doing it, they're going to start thinking about approaches to try to start ingesting some of that information and moving your typical 2-page supply chain audit to a 2-page plus 26 addenda, for the jurisdiction you're in that covers off some of these basic laws. Now, there's an argument that that's the way it always should have been, but that's not reality. But that is, I think, where we are headed. That is where the trends are pointing.
Very interesting. It's certainly an argument for digital certificates on all of
the product passport for sure. Yep.
Right.
Yeah.
Marie?
Well, what you just said, Will, about this, every regulation needs their own reporting and documentation. Still, of course, you need to report on every regulation differently and in a specific policy and in a different document, but the approach is always the same. So it's always, you have the example of modern slavery. So you need to work on modern slavery. The suggestion is to just work on the highest standard, depending on the countries that you're working with, and then you fulfill the other standards. Of course, you need to have the reporting differently, but this is the same with due diligence. This is the same with clients' requirements. You always go for the highest level, for being sure to fulfill these requests, and then you're easily to report to the different regulations and to the different requests and requirements of the clients. Still, this is step by step.
And I completely agree. The core is the same, and you can go to the top. But I do, as a lawyer who handles reporting, I do say you don't easily report. Even so, it's still not easy. But yes, I absolutely agree. The core is the same. Yeah.
So we're at the 1 hour. I'm very adamant trying to always keep things to the time because people, feel bad dropping off. So I am going to cut us. I assume people will reach out to one or both of you, not just when there's a crisis, right? I assume you have ways that you can help advise companies on those, as Maria phrased it, baby steps or the initial steps, and then, Will, I assume from a legal perspective, there's small, medium, and large approaches to, all of this due diligence. So I've got your contact info. If someone wants it, feel free to email me, Rick Levine at naomd.com. Thank you so much, Marie and Will, for taking the time to walk us through all of this. It's both overwhelming, but kind of exciting also that there are some solutions on the way.
Yes,
Yeah, for sure. Thank you so much. We appreciate it.
Yes.
Thanks.